Thank you, Chair, and good afternoon, witness. George Kasabela Kandafula, Member of Parliament, Serenje. Thank you.
Good afternoon, all. My name is Swongile Mwamba. I represent the people of Kasama Central Constituency. You're most welcome. Thank you.
Thank you very much, Chairperson, and good afternoon, the Consortium of Civil Society Organizations. My name is Brian Kambita, Member of Parliament for Zambezi East Constituency in Northwestern Province.
Thank you, Chair. Witness, welcome. Mishek Mtetwa Nyambose. I represent the wonderful people of Chasefu Constituency in Eastern Province and a member of this committee. Thank you.
Good afternoon. My name is Muvita Anakoka. I'm Member of Parliament for Luena Constituency in Western Province. You're welcome.
Good afternoon. Mungandu Davison is my name. I represent the people of Chama South Constituency in Eastern Province. You're welcome.
Good afternoon. Samaka Newton Munilunga.
Secretariat.
Thank you, Chairperson. Good afternoon, honorable members. Good afternoon, witness. My name is Sheila Manasse Mwenya from the Office of the Clerk.
Permanent witnesses.
Good afternoon. Thank you, Honorable Chair. Thank you, honorable members, and good afternoon, Consortium of Civil Society Organizations. My name is Achawezi Chiro. I'm Parliamentary Counsel, and I'm with David Mwengwe, who is equally Parliamentary Counsel from Ministry of Justice.
Thank you. Witness, you are guided to make your submission, and before you make your submission, let me take this opportunity to confer you with Cap 12, which provides for immunity for what you submit before this committee against persecution. And this is the same immunity that members of Parliament enjoy on the floor of the House, and that you're guided not to mislead this committee, or the reverse shall apply. Witness, you are guided to focus on the salient submissions in terms of your specific recommendation on every clause that you have attended to for the amendment of Constitutional Amendment Bill number 7 of 2025. Witness, you are free to make your submission.
Thank you, Chair. To start with, as a consortium, we have been consistent with our submissions and would like to put it on record in this committee meeting that we are going to give a submission that we have been giving throughout when the constitutional amendment process is started. So as a consortium, we start with the electoral process and electoral systems as a whole, Article 45 to 57. Our submission: we propose that elections to the National Assembly and councils continue to be conducted under the first past the post electoral system, complemented by reserved constituencies and ward-based seats for women, youths and persons with disability as prescribed under Article 49. The justification to this, Chair, is that the first past the post system remains the most practical and cost-effective electoral method for Zambia's political and administrative context. However, to align with Article 45(1) C and D, which promotes gender equity and inclusion, the introduction of reserved seats ensures representation for marginalized groups without undermining the principle of universal suffrage and geographical representation. This hybrid model strengthens inclusivity, national unity, and demographic legitimacy. Electoral process and systems as a whole, TOR 3.1, Article 52. We propose that to insert a new clause 5 after clause 4, which will allow for a person who loses a nomination petition before the tribunal to appeal to the Constitutional Court within 7 days of the decision, and for the court to hear and determine the appeal within 21 days after the hearing. The justification is that the right to appeal is a constitutional right under our jurisdiction. The new provision will contribute to upholding justice. Number 2, specific amendments to the Constitution. Delimitation. Submission. Delimitation processes should explicitly consider population growth accessibility and equity to ensure fair representation and administrative efficiency. But this approval for delimitation must facilitate creation of constituency-based seats and ward-based seats for women only, youth only, and persons with disability only to compete and directly be elected by voters. This provision must connect with a possible amendment to Article 162 of the Constitution to ensure that Constituency Development Fund is equitably allocated and distributed. The public will be interested in the proposed increase of seats, and to ensure there is transparency and accountability as required by Article 8, the delimitation report of 2019 must be availed to the committee and the public to ensure we all know where the new seats will be. Justification is that unequal population sizes across constituencies undermine the one person, one vote principle. Incorporating demographic and developmental factors will enhance balanced representation and resource allocation. If the concern is about challenges of developing bigger constituencies to ensure they also receive more CDF, the answer lies in equitable allocation of CDF under the developed constituencies. Representation of women, youth and persons with disability in Parliament and councils. Submission. Article 68 should provide for 5 women, 3 youths and 2 persons with disability elected from each province through reserved seats. Even independent candidates who are women, youths and those with disability must compete with anyone of the same kind sponsored in these reserved seats, and the people must have a final say on who is voted into office and not the political party. Justification. This measure actualizes Article 45.1 C and D and addresses the structural inequalities that limit marginalized groups' participation in governance. Reserved seats offer a constitutionally guaranteed mechanism for inclusion while maintaining democratic elections. The electoral system of direct election by women by electorates during general election rather than being selected by political parties on open or closed list system is that the former ensures that even persons who do not belong to political parties have a fair chance of competing with fellow women or youths or persons with disability. Nominations of members of Parliament. Our submission. Article 52 should be amended to continue with the status quo where the Constitution specifies the timelines for filing and hearing of nomination challenges disputes, but also allow for appeals against nomination challenge to be made to the Constitutional Court and for it to be heard within a shorter period, as the right to appeal is a primary principle of a functioning democracy and the judicial system. The justification is fixed timelines, that is 48-hour filing window to file an appeal, and the 30-day appeal determination ensure speedy adjudication and reduce electoral uncertainty and promote confidence in the electoral process. D. Filing a fresh nomination upon death, resignation or disqualification. Our submission. Where a candidate dies, resigns or is disqualified 30 days before an election, the Electoral Commission should require fresh nominations to be conducted within 72 hours from a political party affected by these events. However, if the resignation, death or disqualification happens within 30 days to an election, no new nomination should be permitted, as ECZ would have printed ballot papers. In that instance, the election must proceed even with the name of the person who resigned appearing on the ballot. The votes obtained by such a person will be considered as a spoiled ballot or invalid. Justification. This balances fairness and practically allowing political parties a chance to replace candidates while preventing logistical disruptions close to elections day. It also upholds the right of a political party to sponsor candidates as enshrined in Article 60 of the Constitution, which should not be taken away without much effort of holding it. Transitional mechanisms and clarity of the tenure of elected representatives. Our submission is that a new clause under Article 81 should entitle members of Parliament to emoluments for the full 5-year tenure of office, including the 90 days when Parliament has been dissolved. For emphasis, Parliament must remain dissolved 90 days before an election. Justification: the clause ensures legal clarity on MPs' benefits and prevent disputes arising from early dissolution of Parliament and administrative transitions. Provisions relating to terms and offices. Number 1, Member of Parliament. Our submission is that provide for members of Parliament to serve for a maximum of 2 5-year term, but the provision should not affect terms already served before its enactment. Number 2, clarify that disqualification on conviction or other grounds takes effect only after final appeal determination. Justification: that this 2-term cap for MPs will ensure uniformity in the 2-term application for the President, MP and councillors, while not barring the current MPs from running for elections. The other provision, that is 2, is meant to preserve the presumption of innocence and prevents unjust removal of MPs pending appeal outcomes. Office of Ministers, Article 116 and 117. Our submission: ministers and provincial ministers should be appointed from outside the National Assembly or councils. This ensures a clearer separation between the legislature and the executive, promoting accountability and reducing conflict of interest. Ministers will still be permitted to attend and contribute to parliamentary debates without voting rights. The hearing of election petitions. We propose that the Constitution must establish an electoral court as a specialized court or division of the High Court to hear all petitions, including electoral disputes by political parties. The court should determine all politically related cases within 90 days of them having been filed, to avoid what we have seen as ongoing legal battles in our courts. The justification is that this will expedite the disposal of electoral matters in a timely manner, including election-related disputes, which must be determined in a timely manner as required by Article 45 of the Constitution. Presidential petitions. Our submission is that we need to introduce a requirement that the Constitutional Court hear and determine petitions and appeals within a fixed timeline. There is need to increase the time frame to 45 days so as to allow the court to evaluate the evidence and deliver an informed judgment. The timely resolution of presidential petitions maintains stability and prevents governance paralysis. Parliamentary and local government petitions. Our submission is that the petitions must be heard and determined within 45 days, and the appeals must be heard and determined within 90 days after being filed in court. The period for filing an appeal must be 7 days after the decision of the tribunal or the High Court. The justification is about uniformity. Is that uniformity promotes procedural fairness and ensures all electoral disputes are resolved expeditiously. Composition of local government and term of office of local government officials. Amend Article 153 to include members of Parliament as ex-official council members without voting rights, and to establish reserved seats in councils. This promotes cooperation between MPs and councils in local development, while reserved seats ensure inclusivity of marginalized groups at the grassroots level. Our submission on definitions. We submit that we need to redefine adult, child and youth to align with international accepted human rights standards. For adult should be defined as 18 years and above. Child should be 18 years including below 18 years including an unborn being. Youth should be a person between 18 and 34 years. Justification. Uniform definitions across laws enhance legal certainty and harmonize domestic legislation within international conventions such as the UNCHR and the African Youth Charter. Connected definitions: remove the definition of discrimination from Article 266 as the one there is in conflict with the one in the Bill of Rights. The court in the 2016 case filed by Godfrey Mianda found the definition of discrimination as unconstitutional. Number 2, equally remove the definition of young person from Article 266 as it is conflicting with the same definition of young person in the Bill of Rights. Reword the definition of public officer in Article 266 to end at saying a public office is any person who occupies public office without any exemption. Introduce a clause that will state that all definitions in the Constitution supersede any definition in any legislation, so as to make the definitions uniform in Zambia, and any definition contrary to what is provided by the Constitution is null and void. This will avoid the ambiguity of different definitions, such as that of a child being different between the Constitution and statutes such as the Juvenile Act and the Penal Code. Tenure of office of the Attorney General and Solicitor General. Our submission is that specify fixed renewable terms, e.g. 5 years for these offices to enhance independence and accountability. Secretary to Cabinet, our submission is that provide constitutional clarity on tenure and removal to safeguard administrative continuity and professionalism, professional neutrality. Justification: fixed tenure strengthens institutional integrity and reduces executive overreach and other issues connected or incidental to specific issues. Allocation and distribution of CDF. Amend Article 162 to require CDF allocation based on equity and the developmental needs of each constituency. Justification: this promotes equitable development, addressing disparities between urban and rural constituencies. Participation of foreigners in local government election. Our submission: permit permanent resident foreigners to contest local government elections but not vote. Justification: this enhances local inclusivity while preserving sovereign voting rights for citizens only. Definitions under Article 266. Our submission: remove definitions of civil society, as no civil society is mentioned even once in the Constitution, and also remove the definition of discrimination as stated by the Constitutional Court in the Mianda case. Revise definitions of public officer and introduce a new clause that ensures constitutional definitions apply uniformly to all registration. Justification: eliminating vague or redundant definitions avoids interpretive conflicts and ensures constitutional supremacy across all statutory instruments. Other constitutional issues: removal of judges and judicial officers from office. Our submission is that judges should be tried by a tribunal appointed by the Chief Justice, while judicial officers should fall under the jurisdiction of the Judicial Complaints Commission. Justification: this maintains judicial independence and procedural fairness while ensuring accountability mechanisms are distinct and appropriate to the rank. Thank you, Chairperson. That is our submission as a consortium.
Thank you, witness. Honorable members, as a submission from a consortium of 8 civil society organizations, I take note that you have extended the scope to other proposals, but however we remain specifically fixed to the clauses proposed for amendment in Constitutional Amendment Bill number 7. Honorable members, you are now free to interact with the witness. Honorable Mungandu.
Thank you very much. I will take you to page 3 of your submission. Submission on Article 6.8 where you've proposed that 5 women, 3 youths, and 2 persons with disabilities elected from each province through reserved seats. Even independent candidates who are women, youth, and those with disabilities must compete with anyone of the same kind sponsored in these reserved seats, and the people must have a final say on who is voted into office and not the political parties. What I want to find out is where, in terms of achieving equitable and inclusive representation for women, youth, and the disabled, which jurisdiction would you give an example that this is how it is done in this country? Or it was just your innovative way of making a suggestion? Then the final one, don't you think this is likely to promote only those with financial capabilities? It's possible businessmen who have children leaving out even a capable youth in that area competing. Don't you think it will promote that or to act to promote those with the resources only, unlike if it is left to the parties to choose based on the merit and the capabilities of these youths, women, and the disabled? I submit, Chair.
Honorable Anakoka and Honorable Nyambose.
Thank you, Chair. A little bit connected to what Honorable Mungandu has just asked you. Can you clarify whether your reference to reserve seats is in the context of reserve constituencies, and how practical that would be vis-a-vis there will be other people in those constituencies who do not fall in the category of women, youths, and people with disabilities. What do we do with their right to participate in governance through contesting elections if you are talking about reserved constituencies? The second one is just a quick one on participation of foreigners in local government elections. What is the justification here? You are saying it enhances local inclusivity, but in what context? What's the mischief you are thinking of curing with this proposal? Thank you, Chair.
Thank you, Chair. Mine is on page 7. Page 7 on Article 153, the inclusion of members of Parliament to the councils. And I want first, Chairperson, to appreciate the team or the witness that you have really appreciated the importance of the MPs to be part of the council, and that is on the justification that you have given. And I will read that this promotes cooperation between MPs and councils in local development. So having appreciated this, but you have given a note there that these MPs should only be ex-officials of the council without voting rights. My question is, what mischief are you trying to address? What if members of Parliament are allowed to have the voting right? Moreover, they will have only one vote. The way it was before, it was changed. What are we fearing for them to have voting rights, whilst appreciating that they should be part of the development agenda? Thank you.
Witness, I hope you are taking note. Honorable Mwamba, then you are free to respond. Then Honorable Panda, you will ask in the next set of questions.
Thank you, Chair. My question is on page 6. Hearing of election petition. I will just go to the presidential petition. in your submission, you have stated that you're looking at the increase of hearing and determining a presidential petition should be 45 days. But yet what the amendment is seeking is to insert the word determine. Right now, there's no problem with the 14 days, but the problem is the determine. The hearing, but there's no determination. So what was the rationale of you to come to the 45 days instead of just ending at the addition of the word determine? Why have you opted to consider 45 days? Wouldn't that also be problematic in its own right for a country not to have a president for 45 days? I submit. Thank you.
Thank you, Honorable Member. Witness, you can attend to those points of clarification from the honorable members.
Thank you, Chairperson, and thank you, honorable members of the committee, for those questions. In responding, Chair, I will allow also the members of my team to be responding. However, I'll start and then they will also add on top. The first question was about the representation of women, youth, and people with disability, and the reserved seat issue. So, as a consortium, when we interrogated the idea of having increased representation of this marginalized group, we realized that the competition is too much out there, and if we go by the part list itself, it also provides an opportunity for favoritism by the political parties, the political party leaders. They may have people that they would favor. However, if we open it up for people to be competing through an election, it provides an opportunity for every citizen who is in that category to compete against each other. Now, these reserved seats could be, every electoral system is determined by people. It is us people who make a system to work. So we can define how those seats can be reserved. For example, we pick on Southern Province. We say in Southern Province we'll have 5 seats for women, 5 seats for men. It is on those seats that we are trying to propose to increase to increase in Parliament, where we reserve. It may not be. It can either be constituency based, but if they are constituency based, like a constituency says Choma Central or Monze Central, then we may also disadvantage those others who wants to stand. But if we just say every province will have seats that are just reserved, and these seats they will be provincially elected by the people, then those are reserved seats without them being named to say this is Monze, this is Choma, this is Pemba, this is Mbabala. But it's just a reserved seat for women, this is a reserved seat for youth, this is a reserved seat for people with disability, and people from across the province vote for those seats, and people from across the province in that category compete for those seats. So that is one. So the methodology could be determined by the people, and we are the people who can determine the methodology that we can come up with those reserved seats. So that is our thinking. Then coming to the involvement of foreigners, we believe in our communities we have foreigners who are developmental in thinking, who can contribute to the development of our communities, but they do not have the authority to do so because they do not have those leadership powers. So if they are given an opportunity to also compete as candidates for them to be voted in, even when they don't vote, then we are giving them the mandate to also bring their ideas of development in those particular constituencies or in the areas where they are. We know, every one of us know that in our communities, people also can point to us, say, that man, if he was not a foreigner, he would make a good leader in this community. So we give them that opportunity. The idea is to tap every knowledge, to tap every skill that is in the constituency for the benefit of the constituency development. But we do not give them the right to vote because they are not citizens of Zambia, but we give them the right to also lead. And
Order witness.
Chair, we have the entire country following these proceedings. Does the law allow foreigners? I thought he meant foreigners by my understanding, is the people who live, because the law at the moment only allows the residents of that ward staying away from the ward. For example, we have a situation maybe in one ward in Ichpala where someone who resides in Lusaka should be able to go and contest in Ichpala. Does he mean that, or he means literally as foreigners? You know, people are following our proceedings, and it's important that our witness clarifies. I submit, Chair.
Thank you, Honorable Mlando. Witness, your submission is foreign nationals who do not hold the citizenship of this country. Is that your submission?
Thank you, Chair. Our submission is actually documented, it's written. We are talking about foreigners with permanent residence. So that is indicated in our submission. So those are the people that we are talking about, permanent residents who may be foreigners but they have permanent residence. I hope I've clarified that, Honorable. Yeah.
Proceed.
So now coming to issues of MPs in Parliament, we feel that an MP is an important aspect of constituency development, and they have actually the right, they need to be given back that the right to belong to the council. But again, we have a debate in this country that an MP going to the council is going to undermine the principle of separation of powers, where the councils fall under the executive and the MP fall under the legislature. So it will be like MPs having an oversight upon themselves. So what we are saying is that because of that disconnect which is there, MPs can sit in Parliament, but when it comes to decision making where voting is concerned, we think that that should be reserved for members of the council who are the executive. So MPs become like ex-officials, and that is just our thinking of maybe trying to cure the issue of separation of power between the executive and the legislature. Otherwise there will be an override, although it was there in the past that MPs were sitting in the council. But I think to cure that, to give that issue of separation of power, that is where we thought MPs can be in the councils but without voting rights. I know my colleagues will add on this. Then hearing of an election for 5 days window that we have given, we have taken serious note of what happened in 2016, where there was it 2016, where there was a petition which was thrown out on technicality just because of days. People are still arguing on the 14 days, and the 14 days were done. So what we are saying is that yes, the proposal in the amended constitution, in the amendment, is talking about just adding determined, but we also feel there is need for enough time for the judges to make informed decisions. There is need for them to also research as they get the hearing, because we are talking about a petition. A petition always is about another person accusing that there was malpractice committed by another person. So just on hearing without research may undermine the issue of justice. So we think that for 12 days it provides enough window for justice to prevail when determining a case. So that's why we have put a window of for 12 days, and we've also said it should be determined heard and determined within that period of 12 days. Maybe let me also come to what the Honorable said, that there will be a vacuum, there will be a gap in that for 12 days without a president. Our constitution, I think, allows for the Chief Justice to act. So there is no gap which is there. If there is an election and the election is held when the president is also campaigning, it means the same process that happens can happen within 45 days. There is no bigger gap that can happen. Thank you. I submit. Maybe my colleagues can also add.
Witness, just for guidance, the Constitution allows the Speaker to act, not the Chief Justice. You can make your submission.
Maybe just to add, I think our thinking was that the 14-day period for hearing of a presidential petition is just too short to ensure a fair and a just process. So our thinking was that to extend the presidential petition time frame to 45 days will enhance credibility and the due process of the law. Thank you.
May I also may I also add something? On the first question over the voting, the addition of women and youth and persons with disabilities, there was a question that came up to say, won't this favor the rich? I don't think it would favor the rich that much. This particular let me call it business. For instance, we have NGOs like NGOCC and the like that are focused on women. They know about women and they know the features that they really need. So if they are the ones that are promoting a particular woman or a particular something that they want to defend about women, if obviously they can, they should be able to sponsor the people that they feel can do one thing that they want or the other. And similarly with people living with disabilities, they know themselves, they already have associations. So if they needed to sponsor people, they should be the ones that know themselves and they can sponsor. So this, to me, I think they stand a better chance to select who best represents them rather than the political parties. Then there's I think back to the question of the presidential petition. I think the increase is just basically is determined by the word determination, because I think the 14 days, if we notice from the 2016 issue, the 14 days literally was wasted within the petition itself, preparing the petitions and all those small things that come up. But how about the determination? So there's the determination, there's a potential appeal, although I don't know whether this could be appealed, because there's now the Constitutional Court, which is the final court. So I think the 45 days to me will be justified by the issue of the determination. I think that's what I could add for now. Thank you, Chair.
Before Honorable Nyambose, I also wanted to ask the witness, where do you draw the line on separation of powers? You're saying the members of parliament, if they go to the council, they must just be ex officio, because they'll be mixing with the executive. Ministers who form the executive are members of parliament, and they sit in parliament, and they provide policy direction, executive policy direction in government, while sitting in the same National Assembly. So is this the basis of your proposed cabinet outside parliament? Is this why you're proposing cabinet outside parliament? Before you respond, Honorable Nyambose, then Honorable Banda.
Thank you very much, Chair. It's a short one. Witness, you have indicated here on a page on the term of office for the MP, councillor and everyone. There's been an outcry out there of unfair treatment to the office of the mayor / council chairperson, where they were in the current constitution, they are only allowed for 2 terms, and the MP goes for infinite period. So what is your take on the unfair treatment of the mayor or council chairperson? What is your position on this one, that they are only allowed for 2 terms? Just to comment on their term of office, only them were restricted. I don't talk about the president, but amongst these other, what would be your position as a team?
Witness, you may wait. Honorable Banda, Honorable Sabao, you had a question.
Thank you, Chair, and witness, thanks so much for your submission. Now, for clarity on the definition section on page 8, are you saying that the unborn child should also be included as a child. Thank you. I submit.
Thank you, Honorable Vanda. Honorable Sabah, do you have the question, or Honorable? Okay, you can proceed, Honorable Sabah.
Mine is a light down, Honorable Chasef, on the term of members of Parliament, though it's not part of our bill, but you brought it in your submission, where you are saying that it should be 2 terms. Now my question is, in which country in the world have a member of Parliament have a term? Because I'm looking at the issue of governance, institutional memory, where you have members of Parliament 2 terms, the president 2 terms. When the president leaves, the whole team leaves. Then what type of governance are you going to have in that particular country? Or it's just we are looking at members of Parliament like it's just business as usual. We're not looking at the value they're adding to the governance system of a country. I submit, Chair.
Thank you, Honorable Sabah. Honorable Mulandu, then witness, you'll be free to respond.
Thank you. It's a rider really on what the Honorable Sabah has just asked. Empirical evidence here at Parliament is that more than 64%, if not 70% of members of Parliament do not make it the second term. This Parliament you are seeing, very few people do the second term. Therefore, the decision whether to retain or maintain a member of Parliament is purely based on the performance of the member of Parliament. Why cap it to 2 terms when the proposal here is actually even also to remove the same 2 term on the mayor and council chairperson, so that people are free? What could be the reason? Don't you think it will bring leadership crisis in the country if after 2 terms also fixing? Because I know it's 2 terms. I can agree with my colleague. Poor performance, we just agree I'll do 2 terms, the next it is you, leaving the people disadvantaged in our communities. What is the major justification? I submit, Chair.
Okay, Honorable Kambita, then Honorable Nakok.
Indeed, it's a follow-up question on the position taken and the debate that is currently prevailing concerning limiting the term of office for members of Parliament. I mean, the proponents, who now include yourselves, of this limitation of to 2 terms of members of Parliament must actually justify why they are pushing such an agenda. I'll put it to you, witness, that this house is such a house where one needs to be there for them to comprehensively understand the rules. It's a house of rules and regulations, and it takes long, you can imagine, to a point where some members have been in this house for close to 5 years now. They have not yet understood the whole rules. Others are actually doing the second term. This house is very complex, and I can give you my own situation. I've been in this house since 2016. I've not yet exhausted understanding this house in full. So that calls for the fact that this house requires experience. And if in developed systems like in the UK, you find people have been in that house for quite several years because of the complexities involved in the business conducted by this house. So don't you think you will have a different position to what you currently have in the light of what I'm just submitting now? And in any case, if you've seen people meaningfully contributing to the debates on the floor of the house, it takes those who are experienced. I submit.
Honorable Gambito, you must declare with interest in your subject. Honorable Anakoka.
Thank you, Chair. Just a slightly different angle on this two-term limit suggestion you are putting forward for members of Parliament. Have you applied your minds to the reality that if we constitutionally bar people from contesting, we are therefore retiring them at the end of their second term. And that retirement comes with a package. Have you considered how or what a costly arrangement that would be for the nation? Thank you.
Witness, you can attend to those, then we'll have the last round of interventions and we'll close.
Thank you, Chair. I'll allow Mr. Chifuwe to answer. Then Mr. Oteka also have to come and top up. And the one for the child definition will be taken by our colleague Derek.
Thank you, Chair. I want to start with, I think, what has been submitted by the Honorable Member here, that if we need to cure some of the inadequacies that members of Parliament face when they come to the House, we must then introduce a parliamentary school, that those who aspire must then be educated so that they are well acquainted of the rules before they are even elected. It becomes easier that way to navigate the rules of the House. We say so, Chair, because we also want to look at the spirit of inclusion. So where we want to leave one to perpetually be the member of Parliament for a constituency, it becomes a monopoly, like they are the only jack of wisdom that the constituency is supposed to tap from. So the spirit behind keeping it is to also, and if you see in our submission, we have not barred them from contesting again. We are simply saying that you must save and leave others also to do the same. So in order to cure those challenges that members face, I think we would suggest, Chair, that we establish a school that would orient them as they align themselves to aspire. So
Honorable members, as we clarify, let us take note that this does not form part of what we are scrutinizing, Constitutional Amendment Bill number 7. So the submission was by the way. The term limits we're looking at are on the mayoral position. So, but you are free to follow up on just guidance.
That's exactly what I was going to. That's exactly what I was going to say, Chair. So my contribution has been overtaken by events.
Okay, yeah. So I think to avoid the back and forth, because you are talking on a matter of interest to everyone here, but nonetheless it's in the submission. And just for information, we have a parliamentary institute, so yeah, but you can attend to the subsequent questions. Witness.
Thank you, Chair, for the guidance. Coming back to the mayoral limit, is it fair, is it unfair? And our submission, Chair, you realize that we are trying to keep the going with the President, the Mayor, and then the members of Parliament. And this is also for uniformity. We must, this is a law we are creating, and it should be fair to everyone. We can't restrict others, and others will leave them open. And so that's the spirit behind the keeping. MPs in the councils, I think it has been mentioned, but I just wanted to say that one of the reasons why we feel they should be ex-officials is that we are imagining that if I'm a councillor and the Minister for Local Government is part of that council, technically that's my boss, and therefore it becomes challenging to try and debate with your boss. So why don't they just be there to provide guidance to the council members as decisions are being made? So that's one of the things that we looked at, and yeah, so I think that's what I wanted to say. The rest has been addressed, but I think with your guidance I will not respond to some of the things that came out.
Honorable Samake, or perhaps there's an intervention. Okay, there's an intervention from Berita.
Thank you, Chair. Maybe for guidance and clarity purpose, I think I would love to reverse you on our Constitution, Article 153, 4D, where we are talking about issues to do with I think just an emphasis for the Chair, which he talks about foreigners. I think the emphasis is on the holder of resident permit. So maybe that's the thinking, Chair, that we are looking at. When you look at 153 4D, I think it clarifies that he has to have the holder is a citizen or a holder of the resident permit, resident in the district, and has a certificate of clearance showing the payment of council taxes, etc. So I think, Chair, that's where we are drawing our authority from, that submission that Chair was talking about. Quickly, from also, I just wanted to point out the issues of term limits. I think a quick Google search, Chair, you realize that, for example, Bolivia, it has 2 consecutive terms for legislators since its 2009 constitution. When you talk about Ecuador also, Chair,
Order. I've guided that we will no longer discuss the...
noted, my Chair. Noted.
They don't form part of the...
Thank you. So I think I'll restrict myself to that. And also the issue of term limits, I think it has been ably said, Chair. When you look at term limits, very soon we'll be hearing submissions from our citizens that the president should be forever. So that's the argument that I think we need to underscore. Why should we restrict the president to 2 term limits when we do not restrict the members of parliament? So I think it's a discourse that we need to be honest with ourselves, Chair.
Order, witness, order. I've guided you. The issue, the particular clause in Constitutional Amendment Bill number 7 is talking about removing term limits on the office of council chairperson and mayors.
Thank you.
That should be a submission. It's nothing to do with the members of parliament, nothing to do with the president.
Thank you. Well noted, Chair. So from that, I think I was just going to subscribe to the issue of also the child. I think our constitution, we were talking about the unborn child. I think clarity also is there in our constitution. When we read Article 22, I think it gives the authority of unborn child. So that's where we're also drawing our authority in that regard, Chair. I submit.
Thank you, Witness. Honorable Samake,
Yeah, thank you, Chair. I'm getting worried with a novel idea that the colleagues that are before us are bringing. For me, that is akin to usurping power, the power of the electorates. And I think we need to leave the issue of the members of parliament to the electorates, because they have got the power to remove, to hire and fire. Honorable Mungando here has said that if you look at the returning members of parliament, I think there could be somewhere around, is it 30-20? About 20%.
Honorable Member, I think we've addressed that. We've exhausted that, and obviously we all have vested interest because we are members of parliament. So I think it's understood, but the submission nonetheless is taken. But you are saying the definition of civil society must be removed from the constitution because the constitution does not talk about civil society. Yet in the same breath you're also saying all definitions must conform to the constitution. So the law the subsidiary legislation that governs civil societies will entrench its definition from where?
Thank you, Chair. I think that one, the definition can happen from the Act itself, whichever the responsible Act. Otherwise, we will have to define everything in the Constitution. So we want to have a lean Constitution. Thank you.
Has there been any complaint with the definition? Is there any mischief with the definition of civil society in the Constitution?
None, Chair.
Okay, Civil Society Consortium of 8, we thank you for appearing before this select committee. We are most grateful for your submission as it has been presented, and we would like to take this opportunity to lift the immunity that was conferred on you and to allow you to enjoy the greater immunity you enjoy outside. We wish you well and have a good day.
Thank you, Chair.
Thank you so much. That was the Consortium of Civil Society Organizations for Good Governance and Constitutionalism, appearing before the Select Committee appointed to scrutinize the Constitution of Zambia Amendment Bill, National Assembly Bill number 7 of 2025. Still to come, we do expect the committee to receive submissions from Measures of Justice and Democracy Foundation. And before that, the committee received submissions from National Council for Students Union, followed by the National Institute for Public Administration School of Law, and a Common Group Network. We urge you to stay glued right here on Parliament TV as we endeavor to bring in Parliament closer to you. Good afternoon.
Baby ni mashuko nachedwa na kuyenda kuchito nipopeko na jinga manasha na yebe yanikuta kaya kapena mazakulapo posimesta desiba na kulepo kapena baby tunde mazakulapo esteri ya mili mumayadi elo nisirivile kumashati elo nanzika nayo ilikuta yesa nikukuruza chape chamaraki na vijana mumayadi nakuila na vela chimusikana maboisi kumbuyo chinidana mamarasha umwanyine na vela na mushe anti awe chifuna marasha ni manguzule mulenge ni jalilesa
lakini manonande